Good afternoon and welcome. It's my enormous pleasure to welcome you to the fourth annual Herma Hill Kay Memorial Lecture. Herma played an enormously important role in the history of Berkeley law. She joined our faculty in 1961 as the second woman to be on the law faculty. She was a leading expert in family law and conflicts of law. She served as the 9th Dean of Berkeley Law, the first woman Dean of Berkeley Law, from 1992 to 2000. She served in so many important roles in the profession, including as president of the Association of American Law Schools. She passed away in June of 2017. Pam Samuelson and Rob Glushko made a generous gift, which was then supported by other faculty members, to create an annual Herma Hill Kay Memorial Lecture. The first was given by Justice Ruth Bader Ginsburg, a close friend and colleague of Herma's. The next two were given by Yale Law School Dean Heather Gerken and Seventh Circuit Judge Diane Wood. Today, we have someone very special to deliver this year's Herma Hill Kay Memorial Lecture, Professor Melissa Murray. Melissa hardly needs an introduction to this audience. A graduate of Yale Law School, Melissa clerked for Second Circuit Judge Sonia Sotomayor and District Court Judge Stephan Underhill. She was a longtime member of the Berkeley Law faculty and served as interim dean in 2016-17. She was a winner of the Rudder Award here for outstanding teaching. She is now the Frederick I. and Grace Stokes Professor of Law at New York University Law School and the faculty director of the Birnbaum Women's Leadership Network. I prefer to think of it, though, as that she's on loan to NYU. I introduce you to the 2022 Herma Hill Kay Memorial Lecture, our friend and colleague, Professor Melissa Murray.
Thank you so much for that generous introduction, Erwin, and thank you so much for inviting me back to give this lecture. It's really lovely to be back in Berkeley, if only virtually, and it's especially lovely to be here to celebrate the annual Herma Hill Kay Memorial Lecture. I know that I am among many who are grateful to the leadership of Pam Samuelson and Robert Glushko, who have generously endowed this lecture as a memorial to a beloved friend and a very dear colleague. I often say that although I am now at NYU, Berkeley is my first academic home. It is the place where I came of age as a teacher and as a scholar. And if Berkeley is my first home, then Herma is my mother-in-law, so to speak. She is one of the first people I met at Berkeley, and as she noted herself, she did as much for me to make a place for myself at Berkeley than anyone else. She was a dear and beloved friend. When I met Herma, she was a giant in the fields of family law, conflicts of law, and sex-based discrimination. And it would not be too fine a point to say that she was already a legend. She was the first woman to lead the Association of American Law Schools and an elite law school like Berkeley among the first women. But Herma very much believed that there was no point in simply being first or among the first if you were also the last. To that end, she spent much of her career at Berkeley nurturing the next generation of lawyers, scholars, and activists. The number of women that Herma helped to steer into the professoriate and then to navigate the rocky shoals of academia is too numerous to count. But this, as much as anything, is her legacy. Literally, there are generations of women lawyers who found their paths because Herma blazed a trail. The topic of my lecture today is reproductive rights, or more precisely, the future of reproductive rights. And again, it is entirely fitting that this should be the subject of an annual lecture in Herma's honor. As a young lawyer, Herma championed many causes in the vein of women's rights, among them advocating for the passage and enactment of California's Therapeutic Abortion Act, which liberalized abortion access in California in 1967, 6 years before the US Supreme Court decided Roe versus Wade. As Herma often recalled, the Therapeutic Abortion Act was signed into law by no less than Republican Governor Ronald Reagan, a telling reminder that in the not too distant past, reproductive rights enjoyed bipartisan support. Obviously, much has changed since 1967, and there is much that one could say about the current landscape for reproductive rights. With that in mind, this lecture looks to the past as a lens through which to consider our present and the future. This lecture is drawn from an article that was published in the spring in the Harvard Law Review. As many of you know, the recent changes in the composition of the US Supreme Court have left many fearful about the fate of abortion rights. And more particularly, many worry that the court will use a pending case, Dobbs versus Jackson Women's Health Organization, to overrule Roe versus Wade, the landmark 1973 decision that famously recognized the right of a woman in consultation with her physician to choose an abortion. In this paper, I agree that these fears for Roe's longevity are well-founded. But I argue that the threats to Roe go beyond Dobbs and indeed may not come from well-worn arguments about the decision's textual fidelity or the workability of the abortion right. Rather, as I argue, the emerging threat to abortion and also to contraception comes from a surprising direction, the ongoing quest for racial justice. So with that in mind, let me roadmap the talk a bit. First, I'd like to say a little bit about the origins of the paper, and in particular, I want to highlight Justice Clarence Thomas's concurrence in a little discussed case, Box versus Planned Parenthood of Indiana and Kentucky, which is at the heart of my argument. In doing so, I'll focus specifically on the paper's three principal contributions and why I think they are important. I'll discuss how the Box concurrence may lay a foundation for overruling Roe versus Wade and curtailing reproductive rights more generally, on the ground that these rights are rooted in racial injustice. And then I'll talk about the history that Justice Thomas sketches in that concurrence. And I'll also discuss my own effort to provide a more complete history. And I'll also explain why that elaboration is both important and necessary. Finally, I'll say a little bit about my intuition that the Box concurrence is not simply critical to the future of reproductive rights, but that it is also critical to the future of the court's race jurisprudence as well. So with that in mind, let me start with a bit about the paper and its genesis. In May 2019, the court issued a per curiam opinion in Box versus Planned Parenthood of Indiana and Kentucky. The case was a challenge to two Indiana abortion restrictions, one of which was a trait selection law, or as they're colloquially known, reason bans, that prohibit abortion if it's intended for purposes of race or sex selection, or because of a diagnosis of a fetal anomaly. Although the per curiam opinion granted cert and upheld one of the challenged restrictions, it denied certiorari as to the trait selection law. This prompted Justice Clarence Thomas to write a separate concurrence in which he chided the majority for denying certiorari. And that might have been the end of things, but Justice Thomas continued, crafting an opinion in which he conflated the history of the eugenics movement and the birth control movement with the history of abortion. As he explained, Margaret Sanger, the founder of what we now know today as Planned Parenthood, worked hand in glove with the eugenics movement to spearhead efforts to expand the use of birth control within the Black community, ostensibly for the purpose of targeting and stamping out Black reproduction. Thomas was no doubt thinking of disproportionate rates of abortion in the Black community today, and perhaps viewing this as the contemporary residue of this earlier effort to market family planning measures to the Black community. Justice Thomas then circled back to the challenged trait selection law, observing that such restrictions were merely the state's modest attempt to ensure that abortion did not fulfill its eugenic potential to eliminate unwanted traits or characteristics. The Box concurrence received some attention, but it was quickly overshadowed by other major developments at the court that term. But I remained absolutely fascinated with this case, in part because it seemed to touch on so many issues that I had focused on in my own research, including the changing discourse around abortion rights, both in the court's doctrine and in society. I've been especially interested in the way that the reproductive justice movement has salted the traditional discourse about access to contraception and abortion with concerns about race and class inequality. As reproductive justice advocates have argued, impositions on the abortion right are not just assaults on women's autonomy and equality. They disproportionately impact women of color and poor women, and as such should be understood as posing intersectional harms. It struck me as I read the Box concurrence that Justice Thomas seemed to recognize the way in which the reproductive justice movement had helped to shift the debate about abortion and reproductive rights to one that engages with race and class as well as gender. In this regard, if the reproductive justice movement in tandem with the reproductive rights movement is arguing that abortion rights are not just about white women, but about poor women and women of color, that is, that abortion restrictions are not just about gender injustice, but about race and class injustice as well, well, then Justice Thomas's concurrence turns that logic on its head by countering that the real racial injustice is not what abortion restrictions do to women of color, but rather what abortion can do to communities of color. And Justice Thomas is well positioned to make that intervention. He's always been stalwart and transparent about his objections to the abortion right, and he's also the person on the court who often raises questions of race and racial injustice, including in cases where race is not obviously salient. And it occurred to me as I read the concurrence that it was not a one-off, as some commentators had suggested. Rather, it was an effort to seed new ground in the abortion debate, to transform the meaning of the abortion right. So what might the terms of this new debate look like? On one level, the Box concurrence bolsters a defense of trait selection laws that has already been percolating in lower federal courts. Indeed, in the Seventh Circuit's disposition of Box, Judge Frank Easterbrook wrote a dissent, which then Judge, now Justice Amy Coney Barrett joined, in which he suggested that trait selection laws might fall outside of the scope of Casey and Roe because those cases had never considered abortion restrictions that were not aimed at promoting women's health, but rather were positioned as fetal anti-discrimination measures. The Box concurrence provides additional support for that idea that state-level restrictions on quote-unquote eugenic abortion function as anti-discrimination measures for the fetus and thus were not contemplated by Casey and Roe and are outside of the terms of those two decisions. And to be clear, the Box concurrence has already been cited for that position, both in amicus briefs filed in challenges to trait selection laws and among members of the federal courts. In January 2021, the Eighth Circuit invalidated an Arkansas trait selection law that prohibited abortion where there was a Down syndrome diagnosis on the ground that it functioned as a pre-viability ban in violation of Casey. But even as it struck down the law, the majority opinion also noted that the court could, in time, revisit whether Casey applied to trait selection laws at all. And in a concurrence, Judge Bobby Shepard explicitly cited the Box concurrence, noting that Casey's viability standard, quote, does not and cannot contemplate abortions based on an unwanted and immutable characteristic of the unborn child, end quote. More recently, the Sixth Circuit upheld a challenged Ohio recent ban. There, the majority opinion and all of the concurrences cited or referenced the Box concurrence and the prospect of quote unquote eugenic abortion. So it's clear that the concurrence has had immediate implications for challenges to reasons bans. But as I read the concurrence and ruminated upon it, it seemed clear to me that the concurrence's import was not limited to a defense of reason bans as anti-discrimination measures. To me, it seemed the concurrence and its efforts to change the social meaning of abortion by associating abortion with eugenics and the Black community was perhaps part of a longer range strategy to destabilize and eventually overrule Roe versus Wade and constitutional protections for contraception. So one of the distinct contributions of this paper is to explain how this could happen. As I explain, by associating abortion with eugenic racism, the Box concurrence lays a foundation for discrediting and ultimately overruling Roe versus Wade on the alleged ground that the abortion right is rooted in and tainted by racial injustice, and specifically the eugenic effort to selectively target and impede Black reproduction. The argument is even more forceful for contraception in Griswold versus Connecticut, the 1965 case that announced the right to privacy and in doing so ushered in a privacy revolution at the court. According to Justice Thomas, Margaret Sanger's associations with the eugenics movements irredeemably taints modern day contraceptive use with the brush of racism. It transforms an act of individual autonomy into a racialized assault on minority communities. Because of stare decisis, past decisions like Roe and Griswold cannot be overruled simply because a majority of the current court disagrees with them. Instead, a special justification is required. Justice Thomas's association of abortion and contraception with eugenics begins to construct the case that racial injustice is the special justification that warrants overruling Roe and possibly Griswold. The idea that race and remedying past racial injustices can serve as a special justification for reconsidering past precedents is well established in our constitutional history. In Brown versus Board of Education, the court famously revisited Plessy versus Ferguson, concluding that the earlier court had failed to appreciate both the changed nature of public education in our society and the psychological damage of segregation on Black children. Likewise, in 1967's Loving versus Virginia, the court overruled Pace versus Alabama, concluding that its equal application theory was incorrect and focusing on the fact that Virginia's miscegenation laws were undergirded by an interest in maintaining white supremacy. In October term 2019, we saw a similar impulse in Ramos versus Louisiana, which invalidated Louisiana's policy of allowing criminal convictions to proceed from a non-unanimous jury verdict. The question of whether non-unanimous juries were consistent with the Sixth Amendment had already been considered in 1972's Apodaca versus Oregon. But the Ramos court nonetheless concluded that because Apodaca was out of step with extant Sixth Amendment jurisprudence, and because the Apodaca court failed to reconsider the non-unanimous jury rule in light of the rule's origins in a Reconstruction era effort to entrench white supremacy, the 1972 decision could be properly reconsidered and ultimately overruled. The court's disposition of Ramos suggests how Roe could similarly be revisited and overruled. For years, those opposed to abortion have argued that Roe lacks a foundation in constitutional text, was improperly reasoned, and has proven unworkable over time. Despite these efforts, Roe has survived. But Justice Thomas's racialized critique of abortion furnishes new justifications for reconsidering and overruling this embattled decision. Specifically, it provides new factual circumstances steeped in race and racial animus that may suffice to render Roe, as the Ramos court put it, a remnant of an abandoned doctrine. To the extent the Box concurrence provides a path toward overruling Roe, its logic absolutely depends on Justice Thomas's effort to graft the history of Margaret Sanger and the birth control movement to eugenics and to abortion. But as historians and commentators have noted, the history that Justice Thomas deploys for this effect is both selective and incomplete. With that in mind, the paper's second distinct contribution is to supplement Justice Thomas's account of the racialized history of reproductive rights discourse with alternative voices. As I explain, the idea that the association of race and reproductive rights emerged with Margaret Sanger and the eugenics movement of the 1920s is absolutely wrong. The entire history of the regulation of reproduction in this country has been shot through with questions of race since the days of slavery. And indeed, concerns about race shadowed the efforts to regulate reproduction after the Civil War and through the 1920s and into the 1960s and the Civil Rights Movement. As I argue in the paper, the idea that broader access to birth control and abortion are part and parcel of a broader effort to curb Black reproduction and limit the political power of the Black community was first articulated by Pan-Africanists in the 1930s and was later reprised by both the Nation of Islam and the Black Power movement in the 1960s and the 1970s. In this regard, Justice Thomas isn't saying something original. He's actually tapping into a vein of discourse that has been in circulation in the Black community for some time. The trouble, of course, is that the view that family planning is part of a racist conspiracy to marginalize and subordinate the Black community is not necessarily shared by all within that community. Civil rights leaders of the 1960s, including Martin Luther King Jr. and Malcolm X, were supportive of family planning measures on the view that being able to control the size of one's family was an absolutely critical element for stabilizing the Black community's economic circumstances. And in making those arguments, Dr. King and Malcolm X were merely echoing the arguments of notables like W.E.B. Du Bois, who worked with Margaret Sanger and the birth control movement to expand the Black community's access to family planning on the ground that it was necessary to stabilize the community's economic fortunes. And as importantly, Black women in the traditional civil rights movement and the Black Power movement vehemently voiced their objections to what they saw as a masculinist association between abortion, contraception, and racial genocide. So these were women like Toni Cade Bambara, Shirley Chisholm, Angela Davis, and Florence Kennedy, all of whom made clear that if we were going to talk about racial genocide, then the problem wasn't widened access to contraception and abortion, but rather the persistent problem of state-sponsored sterilization abuse, or the injuries caused by unsafe and illegal abortions, or the challenging circumstances in which Black women were forced to raise their children. In the paper, I provide this additional history because doing so is important for three reasons. First, overruling Roe on the grounds that it is a remnant of racial injustice depends on the history that Justice Thomas has crafted, a history in which the abortion rights founding moment is not in Roe in 1973, but rather is in the eugenics movement of the 1920s and 30s. But as the paper shows, the history on which Justice Thomas relies is deeply contested, particularly insofar as it conflates the history of the birth control movement with the history of abortion regulation. More importantly, the history confirms that there were voices in the Black community who were distrustful of family planning and associated with it with government-sponsored genocide. But meaningfully, there were other voices, particularly those of Black women, who welcomed widened access to family planning as a means of improving the collective fortunes of the Black community. Providing this counter history arms both reproductive rights advocates and members of the judiciary with a more robust historical account with which to challenge the Box concurrence and the effort to reshape abortion doctrine and the social meaning of abortion. From a litigation standpoint, this is especially important given the difficulty of verifying facts contained in amicus briefs that are submitted to the federal courts. Currently, Justice Thomas's historical account is the one that is being integrated into anti-abortion amicus briefs in the lower federal courts, and at present, there is no mechanism for contesting the content of those briefs. The history that I provide gives pro-choice advocates a means of challenging that historical narrative, or at the very least, provides a mechanism for making clear to the courts that the history is more complicated and contested than the Thomas narrative suggests. But this counter history doesn't simply serve doctrinal or litigation functions. It also serves a political function. If the Box concurrence makes Black women unwitting dupes in a eugenic plot, or worse, willing co-conspirators in that plot, then this counter history actually surfaces the voices of Black women themselves and makes clear that they understood these claims of racial genocide and that they forcefully contested and rejected them. And that kind of representation is vitally important in the politics of judicial deliberation. As I argue in the paper, when Justice Thomas speaks on the court about issues of racial justice, he does so with a kind of epistemic authority that comes from being the only African-American on the court, at least for now. Likewise, the addition of Justice Barrett to the court may serve a similar function. When the question of Roe or abortion more generally comes before the court, as it did in December in the oral argument for Dobbs, Justice Barrett will likely be skeptical, as she was there. But because she is a woman, her skepticism of abortion as a means of promoting women's equality and autonomy will likely be imbued with a kind of epistemic authority that may resonate, if not with her colleagues, then with facets of the public. And in a similar vein, Justice Barrett, who is the mother of 2 Black children and a child with Down syndrome, may also be vested with a particular kind of epistemic authority on the question of the constitutionality of trait selection laws and whether or not they function as anti-discrimination measures. Given that within the court, certain views and constituencies will be represented in deliberations on the question of abortion and its intersection with issues of race and inequality, it is worth thinking about what constituencies will go unrepresented. And in this regard, the history that I provide gives voice to the concerns of Black women around these questions at a time when they are, for this term at least, unrepresented among members of the court. Finally, the paper argues that the narrative that Justice Thomas puts forth in the Box concurrence is not just devastating to Roe, but that it will have devastating consequences for contraception and reproductive rights as well. If the court accepts Mississippi's invitation to overrule Roe in Dobbs versus Jackson Women's Health Organization, that will not be the end of things. This narrative of reproductive rights originating in racial injustice can then be used to fuel calls for fetal personhood. And if reason bans are essentially anti-discrimination protections for the fetus, then it follows that more robust protections, including constitutional protections for the fetus, should accrue as well. Additionally, the narrative of reproductive rights as racial injustices may also be deployed to discredit, dismantle, and indeed overrule the right to privacy, the right that essentially scaffolds so much of our intimate life. But that's not all. As I argue in the paper, the box narrative and its logic of abortion as eugenics also has implications for the court's race jurisprudence. If Justice Thomas has been transparent about his skepticism of abortion rights, he's been equally transparent about his interest in issues of race. He's weighed in very interesting ways in cases that very obviously implicate questions of race, including his dissents in Grutter versus Bollinger and Virginia versus Black. He's also injected race into dialogues which are not immediately obvious as racialized in cases like Kelo versus City of New London or McDonald versus City of Chicago. Accordingly, when I read the box concurrence, it seemed unfathomable to me that Justice Thomas would go to such great lengths to engage the issue of race without intending for it to have repercussions in the arena of race jurisprudence as well as reproductive rights. So this is all to say that I am convinced that this concurrence has implications for race jurisprudence. I'm just not sure that they're as obvious as the obvious implications that portend for reproductive rights. On the one hand, I think that Justice Thomas's reliance on the disproportionate incidence of abortion among Black women may signal that although some members of the court have been unwilling to see disparate impact as probative of a racial injury, maybe they are more willing to do so in certain circumstances when other values are at stake. However, Justice Thomas anticipates that critique. He's made very clear his opposition to disparate impact theory, and he makes clear in the box concurrence in a footnote that he's not providing a shift in disparate impact doctrine through this line of reasoning. But regardless, if the logic of the concurrence is successful in overruling Roe, it will do so at least in part by relying on evidence of disparate impact. And that may suggest that perhaps there's more play in the joints on those issues. Now, that is a very optimistic vision of the race landscape. So let me put that aside and indulge my ordinary impulse toward pessimism where the court is concerned. The other place where the concurrence has implications for race jurisprudence is, I believe, in our understanding of what constitutes a racial injury. Part of what the concurrence does is to signal that the kind of racial injury for which constitutional redress is available is actually quite extreme. Not just ordinary segregation or prohibitions on interracial marriage, but the kind of egregious evil that we associate with genocide and deracination. To be sure, I'm not sure that that is where the court will ultimately come out in terms of its race jurisprudence, but I do think it is worth thinking more about. And it strikes me that we have overlooked entirely, as we often do with much of Justice Thomas's work, the way in which this concurrence is operating at multiple levels. And in doing so, will have profound impacts on decision-making at both the court and the lower courts for quite some time. So with that said, I will stop here, and I'm delighted to take questions about this. But once again, let me underscore how grateful I am for the invitation to share this paper and these reflections with you. If it is not already clear, this paper and much of my work more generally is informed by and has benefited enormously from Herma's mentorship and friendship and guidance throughout my career. It is an incredible honor to be invited here to share this work at an event that specifically honors her and her enormous legacy. So thank you very much.
Melissa, thank you so much for that terrific presentation. People can send questions to the Q&A function or to me directly. I've gotten a few questions already. The first was, how does Justice Thomas's theory account for Black women who believe in abortion rights or who choose to have abortions?
It's a terrific question. I don't know that it does at all. In other work, I've talked about Justice Thomas's the avatar of the Black patriarch that really punctuates a lot of Justice Thomas's work, including most recently his concurrence in McDonald versus City of Chicago. That was the case about the incorporation of the Second Amendment to the states. And Justice Thomas wrote a very evocative concurrence in which he spoke of racial violence against newly freed African Americans during Reconstruction and Redemption, and how the right to bear arms was actually pivotal for the survival of these communities, and the absence of the protection of that right led to their destruction. But if the Black patriarch is this avatar that Justice Thomas really leans into, we don't see much in the way of Black women exercising the same kind of pivotal role in securing the Black community. Indeed, what we have is this idea of Black women who selfishly deploy this right that is rooted in autonomy, but not necessarily in the collective fortunes of the Black community. And in so doing, they have selfishly admitted to the bosom of the Black community the abortionist, the very person who could, in a single swoop, deracinate the future of the Black community. And so it is interesting to see the way in which he sort of oscillates between this idea of collective fortune and individual right. And the individual right, when exercised by Black women, is an assault on the collective fortunes of the community.
Another question that's come in: is it possible for the court to overrule Roe without also putting Griswold in jeopardy? If Roe is overruled, states are likely to have laws prohibiting IUDs, morning after pills, and other methods of contraception. Is there a way to strike these laws down if Roe is overruled?
So I think if Roe falls, then Griswold is certainly implicated, because the right to privacy is the underlying right that roots Roe. And I think we've already begun to see the assault on the entire line of substantive due process rights that includes the right of privacy, but goes beyond just contraception to also include the right of parents to raise their children in the manner of their choosing, the right of individuals to marry the person of their choosing. All of that, I think, is in question now. There's an AG's directive in Texas that prevents parents from providing their children with gender-affirming therapy. And last week, in the confirmation hearings for Judge Jackson, one of the senators sort of spoke of the rights of parents as an unenumerated right that had no rooting and no mooring in constitutional text, and was somehow an illegitimate right when compared to quote unquote text-based rights. So I don't think it is too far of a limit to say that once Roe falls, there is more in the offing, and we're already beginning to see that. And as you've suggested in the question, there are a number of different contraceptive technologies that have been likened to abortifacients. We saw this in the Hobby Lobby case, for example. So IUDs, for example, or the morning after pill are viewed as not just contraception, but abortifacients because they prevent the implantation of an egg in the uterine wall. Once you classify certain forms of contraception as essentially abortions, I think it is easier to extend the logic of whatever the opinion is overruling Roe to contraception as well. But I also think the discrediting of the right to privacy furnishes independent grounds for just dealing with all of contraception, not simply those that are considered abortifacients.
Thank you. And again, if anyone has questions, please put them in the Q&A. I have one more that's come in. Before Roe, many more Black women and Latinas died from illegal abortions. Isn't that likely to happen again if Roe is overruled? If Justice Thomas' concern is the lives of people of color, what about these women?
So it's a great question. Yes, there's ample evidence that in the pre-Roe landscape, the limitations on access to abortion and the illegality of abortion was borne most heavily by poor women and women of color. And I think that's likely to continue. We've already seen, even in a landscape in which Roe is available, but is a nullity for a number of women, that it is poor women and women of color who bear the brunt of those restrictions most heavily. And that is likely to continue in whatever the settlement is after the Dobbs case. I don't know what to say about how Justice Thomas feels about the Black women and the women of color who will bear those burdens disproportionately. As I've said, we don't hear a lot about his views of Black women, although he writes quite frequently about this avatar of the Black patriarch. Most of the time when I think we've heard him speak of Black women, it has been in the context of his discussions of his mother and his sister. He's spoken about both of them in his autobiography and again to biographers. And he's talked about his sister who is in receipt of public assistance and talked about how the fact of her receipt of public assistance left her entitled and constantly looking for her check. And so it's a kind of, unfortunate depiction of Black women. And I don't know that we have an alternative for that. But it is, I think, a real contrast and to the depiction of the Black women that people like Toni Cade Bambara and Shirley Chisholm and Florence Kennedy were offering in the 1960s and 1970s, when this argument about racial genocide was very much on the table. And they were arguing that they wanted control over their reproductive capacities because they wanted to be a part of the Black nationalist movement. And if they were going to fight alongside their men, they argued they couldn't be held down by the burdens of parenthood and raising children. And if they were going to raise children, they talked about the really difficult conditions in which they were doing so. And that, if the state were going to provide support or were going to limit access to abortion, maybe that would be the place to start, make the conditions of parenthood more equitable.
One more question is coming. Will Justice Thomas' ability to articulate the perspective of the Black community be limited or changed by the presence of another Black justice in Justice Ketanji Brown Jackson?
I think surely that will be the case. Justice Jackson, I'm talking about this as though it were a fait accompli because I think it is. Justice Jackson will be the second African-American on the court, but she'll be very different from Justice Thomas, if for no other reason that they are from entirely different generations. Justice Thomas is a septuagenarian who was raised in the heat of Jim Crow in Pinpoint, Georgia. Justice Jackson will be a 51-year-old woman who's really been raised in what President Obama called the Joshua generation, of the generation that really reaped the benefits of integration, understood and attended integrated facilities and institutions. And I think that by itself will be quite different. It's interesting. There was a biography of Justice Thomas probably 20 years ago by Kevin Merida and another author in the Washington Post, where they actually interviewed a young Ketanji Brown Jackson about her time as a clerk to Stephen Breyer. And one of the customs on the court was that the chambers of the other justices, like you went to lunch with all of the other justices. So the Breyer chambers went to lunch with Justice Thomas. And she tells the interviewer, there he was, he's sitting across from me and he looks like my parents, he sounds like my parents, but the things coming out of his mouth are nothing like what my parents would say, nor is it anything that I would say. And so it's very much a different experience. And she finds him not only unfamiliar, but absolutely foreign in his understanding and interaction with the Black community. So I think that will be very different, just a completely different intergenerational moment between the two of them. I think she'll also be joining Justice Barrett as the second working mother on the court. And unfortunately, she won't be there when the court takes up the challenge to abortion, but I think it would have been very interesting if she had been there as a counterpoint to Justice Barrett, who at oral argument, really talked about the whole prospect of whether we could disaggregate the burden of pregnancy from the burdens of parenthood. And if we could, was there really a need for an abortion right if women could be relieved of their parenting obligations by simply surrendering a child for adoption at a safe haven site like a firehouse or a police station? Justice Jackson would come from a group that has the highest maternal mortality rates in the country, for whom pregnancy is still very much a significant risk. And it would have been interesting, I think, to see that perspective in conversation with some of these other views in December when the Dobbs case was argued.
Another question came in. Mississippi argued in Dobbs that no other right involves the purposeful termination of potential life. How do we respond to the weighing of individual rights against the state's interest in potential life?
I think this has been a challenge in abortion litigation, at least since Casey, when the court made clear that the state's interest in potential life is perfected at the beginning and continues throughout the course of pregnancy. This has always been sort of a fundamental question. And I think Justice Sotomayor really put it to the court and the public during the Dobbs oral argument when she asked, where do we start to value the life of the women? Where does that come into the calculus? Mississippi is an interesting case because they are very much focused on the potentiality of life, but they also argue that they are focused on promoting the health of women, but yet as a state, they rank last in terms of the availability of Medicaid. They rank last in terms of maternal mortality. They rank almost last in terms of infant mortality. They rank very near last in terms of access to sex education. All of the things that they could do to promote women's health, they don't do. The one measure they do take for the promotion of women's health is to restrict abortion. So again, I think the interest in the potentiality of life probably outweighs all of the other reasons that they've offered for this particular restriction.
No other questions come in. You spoke about providing an alternative set of facts for district courts and up to use, and referred to the narrative being promulgated by Justice Thomas. While you're right that the formal source you're providing is critical, do you believe the sitting justices that are poised to overrule Roe will actually consider a different narrative?
No, that's the beauty of being a law professor. We can talk about these things, but here's the thing. Many of these cases are not always going to be destined for the Supreme Court as the final arbiter, and there's a lot to be done in the lower federal courts as well. And I think even laying a groundwork for contesting a narrative, whether it is in dissent at the Supreme Court, or in dissent, or perhaps even in a majority at a lower federal court, is worth something, because right now this narrative is utterly unchallenged, right? So in the Sixth Circuit case that came down a few months ago, there were, I think, 5 different concurrences, and all of them repeated and reiterated the logic of the box concurrence. And then there were, I think, 2, maybe 3 dissents, and none of them could counter the box concurrence with any kind of historical narrative that suggested that the history that the box concurrence was offering was actually wrong, or at least incomplete. And so I think there is something to be said for allowing a narrative to be reiterated and spun unchecked, and just being able to dissent and show that, yes, there actually is another way to look at this, and getting that on the record. So no, will it change hearts and minds? Probably not. Will it affect the outcomes? Maybe not. Certainly not at this Supreme Court with a 6-3 conservative supermajority. But I think it is important, just as a matter of accuracy, that it is in the record, that this is not the only narrative that is available.
I think that's all the questions that we've gotten. So I just want to thank you for your brilliant presentation. We so miss you at Berkeley Law. I like the image of thinking of Herma sitting on a cloud, smiling at your presentation, even though she'd be terrified by what you described. So Melissa, thank you so much for doing this.
Thank you so much for having me. I wish I could be there in person with you all, and my heart is always in Berkeley. So thanks for having me.
See you soon. Thank you. And thanks to everyone for coming today. This is such a special and important part of the law school.
Thank you.